Okay. I want to welcome everybody for taking time out of their day to come to our AMA, Ask Me Anything live stream. My name is Brian Horlick. I'm a condominium lawyer, as many of you know. And we do this live stream every Wednesday at 12 noon without fail. And we discuss anything you'd like to know about condominium law. We talk about COVID-19, but we also talk about a lot of other things as well. Why do we do what we do? As I've mentioned previously, we're in a very social business, whether we are directors, condominium managers, auditors, or lawyers. We always deal with people. And unfortunately, during this unique period of time, we are all self-isolating, and it is becoming difficult to do what we do, although we are trying our very hardest to do what we do on a remote basis. So we want to make sure that everybody's connected as best as possible. We have information to give you. We're happy to share that with you. We have a chat line for you to write in or type in any questions you have. I'll be happy to answer them to the best of my ability. Now, if you're happy with what we're doing, I'm going to ask you at the end if you could leave a Google review. That would be helpful. You can also press right now the subscribe button, and you'll be getting our notifications as we move ahead with our YouTube channel. I will tell you that, as a lot of you know, every Monday, our office sends out a COVID-19 FAQ, and that is a document that sets out the latest questions and answers on COVID. It's fully up to date. Every week we update it. In fact, it's become the industry standard where a lot of managers and directors are looking forward to Mondays to get the most up-to-date COVID news. And recently, we received quite a number of compliments from condominium lawyers who say that their firms that practice condominium law look forward to our COVID-19 bulletin every Monday, so they too can be updated. So Monday, look forward to your COVID-19 FAQ, totally updated and consolidated question and answer sheet. Wednesdays, again, we have the AMA Ask Me Anything, where we will host these live streams. And what we are going to do now, moving forward, because COVID-19, we'll fight it, and it's not going to be here forever. So moving forward, we're going to start doing every Friday something called Case Law Corner. And we are going to be sending out to all of our subscribers, to the condominium community, very short snippets of case law, which will be summarized by our condominium lawyers. So myself or Bradley, who's been doing the AMA as well, along with Mr. Tim Duggan, Paneet Bandel, Bharat Kapoor, Alex Etkin. All of us will be taking turns. We have our newest associate, Ann Nguyen, condominium lawyer as well, and she'll be actually taking up the first summary for case law. So it's going to be coming up on Fridays, Case Law Corner. For those of you that were on the live stream last week, 2 weeks ago, we implored Doug Ford to move forward and take care of the condominium industry. And we said to Doug Ford, if you're listening, as we knew he was listening, you need to set out in the emergency orders what the condominium industry is going to do with respect to the provisions in the Condominium Act regarding meetings. Because as we all know, the Corporations Act was amended by way of the emergency order. So their ability to have AGMs was set out as 90 days after the emergency orders are rescinded. But nothing was said for condominiums. So good to know Doug Ford was listening. Good to know that Doug Ford has now expanded the emergency order for condominium corporations, where condominium corporations who are waiting for their AGM to come up, but are not going to have the AGM during the emergency orders because of the prohibition of having more than 5 people in attendance. Condo corporations now know that their period within which to have their AGMs will be within 90 days after the emergency order is rescinded. And in the event condominium corporations have their AGM within 30 days after the emergency order is rescinded, they have in fact 120 days to hold their AGM. So, Doug Ford, thank you very much for listening to the condominium community, and thank you for listening to our live stream. So we're going to move on now to a number of other issues. So first of all, we're going to answer some of the questions, and I presume some of the questions will relate to the Emergency Management and Civil Protection Act, and especially for meeting of AGMs. So let's go to our questions. Hi, Brian, nice to see you. All right, nice to see you, Olivia, as well. First question, do you expect in the near future that the government will approve electronic meetings on a permanent basis? Well, I think what's going to happen is the amendment or the emergency order is going to be rescinded once the emergency is over. Condominiums now have the ability to have electronic meetings, but they have to put in place a bylaw, and the bylaw would allow condo corporations to have meetings electronically. So I don't see that becoming a permanent thing. I do see that moving ahead, people will be able to do this as they are doing it now by way of a bylaw. And in addition to that, you need to not only be able to have an electronic meeting, a virtual meeting, but you have to be able to, at that meeting, be able to vote electronically. And again, the Condominium Act is set up so that you are able to vote electronically by way of a bylaw. So this order that Premier Ford put out allows condo corporations to move forward with electronic meetings and with electronic voting without the necessity of a bylaw. Thank you, Phil, for asking your question. All right. Sylvia, interesting questions here. Are there any extensions to directors whose terms has expired? And if a board elects to delay the AGM, is the term of the director expired, and can the board appoint someone until the next AGM? Okay, so first question, are there any extensions to directors whose term has expired? So there's no extension per se. However, the Condominium Act sets out that even if your term has expired, you continue to be a director until such time as the meeting takes place. So the fact that you haven't held your AGM within the 6-month period of time doesn't affect the directors. They still continue to be and to be able to act as directors. The next question is, if a board elects to delay the AGM, is the term of the director expired, and can the board appoint someone until the next AGM? The term may be expired, but the director continues in office until the election is held. And given the fact that the board member continues in office until the election, that still would allow the majority of the board, if they have a quorum, the majority of the board to appoint a director. So in the situation where there is a vacancy on the board and the AGM hasn't been held yet and the term has expired, you would be able to appoint a director. Now here's another good question from Miriam Hamill. Our landscaping contract has a monthly fee for the year. As there is no grass cutting taking place, do we have any leeway regarding the monthly fees we are paying the landscaper? Well, that's a very good question. And that question is being asked a lot now, not only for landscaping contracts, but for any contract where there is a, let's call it a non-essential service, and the contract sets out that the payments are to be made monthly. So what you need to do is you need to look very carefully at the terms of your contract. And in some contracts, there's going to be something called a force majeure clause. Others will not have that clause. So what is a force majeure clause? A force majeure clause is a clause that basically says, if there is some type of an intervening event as specified in the contractual clause, and the ability to provide the service is affected or cannot be provided at all, then there's a consequence, and the consequence can be either the contract is terminated, or the contract is suspended, or whatever else the actual clause says. So to answer you correctly, the force majeure clause A has to be in the contract. It cannot be implied in the contract. And number two, you need to review the specific clause for exactly what it says. Now, you would think that if you're not going to be getting the non-essential service, you might want to think about renegotiating that contract, or you may want to consider terminating that contract. Again, we don't know how long the emergency order is going to last, and we don't know how long the situation is going to be. We are now starting the month of May. And as the rhyme goes, you get the showers in April and everything grows nicely in May. However, landscaping is not an essential service, and many condo corporations would not look favorably, or residents, on having non-essential workers come to the property. So you need to look at your contract. Next question. If a board loses quorum and appointment of suitable owners are not available, what are the next steps? I think I'm going to shoot myself. So if you don't have quorum, if a board doesn't have quorum, the board cannot conduct any condo corporation business. So if you have a board of 5, your quorum is 3. If you only have 1 or 2 directors, they cannot conduct condo corporation business. The fact that they lost the quorum means also that they cannot appoint, because you can only appoint another director if you have a quorum. I think that in a situation like this, and we have 2 situations like that presently in the office. I think what you have to do is find somebody, a person who will be able to move onto the board. You have to have an electronic meeting or a paper meeting for the purposes of the one agenda item, and that would be to elect someone to the board. Otherwise, you can't move forward. The Condominium Act is very clear on that. So thanks, Jerry DiDonato. Arnold Mochtinger. Regarding electronic meetings, do you see the requirement having a unanimous vote change to a majority vote? Do you see the requirement having a unanimous vote change to a majority vote? I'm not quite sure of the question, but I will tell you there's 2 types of meetings, obviously. One is directors' meetings, and one is unit owner meetings. For electronic board meetings, there is a provision in the Condominium Act that you need to have unanimous consent of the board members if you're going to have an electronic meeting. So that's telephone conference, Skype, Zoom, etc. However, given the suspension order of Premier Ford and the amendment now in the order, you do not have to have the unanimous consent for a board meeting any longer. So during this period, when the emergency order is in place, you are able to have meetings of directors. You don't need unanimous consent. So that's number one. Of course, meetings of owners you can now have electronically, and that was previously in the Condominium Act. It said you had to have a bylaw. The interesting thing about that bylaw is that it was a bylaw that only required to be passed by a majority of the owners in the meeting, not by a 51% majority of owners. But you will need a bylaw. Although right now, due to the emergency order, you can have electronic meetings and electronic voting as of right. Thank you, Arnold. Adib Nasehi. Can board member roles or titles change during the course of the year? If so, would you suggest what would be the best way to suggest a change in title roles? So titles, for example, president and secretary, treasurer, etc. All of these things, other than the president, is something that is an appointment, and so you can be appointed to these various positions on the board. With respect to being the president, that is something that the board has to have an election on. So the board members would elect the president, but the board members can appoint the other officers. So how would that work? Someone would bring a motion to say, I appoint Arnold Mochtinger, Jerry D. Donato. I appoint you as the, secretary of the corporation, and there would be a seconder, and you could have the vote, or just a simple appointment. So that's the way it works over there. Christina Ajith. Are repairs that take place in a unit that are caused by damage in the common elements, a roof leaks and causes water damage in a unit, eligible to go through the reserve fund? Good question. I will tell you that the reserve fund can only be used for major repairs and replacements. The reserve fund cannot be used for anything else. So a leak hardly would classify a roof leak causing water damage into a unit does not seem to fall within major repairs and replacements, which leads us to a further question that a number of industry people and unit owners have been asking, and I think everybody should know the answer by now, but if not, we'll reiterate it. Can reserve fund monies be used to pay common expenses during the COVID period of time? And the answer is no, they cannot. Reserve fund, again, is for major repairs and replacements. There is some thought that, if you don't deposit the reserve fund money into the reserve fund and you adjust your funding plan, there is some thought that you could use those extra funds for operating expenses. Bob Ross, question. Electronic meetings. How did we manage a situation where not all of our owners can participate electronically? That's an excellent suggestion, an excellent question. We are having discussions with many boards of directors on whether they should be moving forward with their AGM or not. Given the fact that they can now do so electronically, the question has become, should we do so electronically? Our position is it depends on your community. It depends on your ownership. If you have a very mature ownership, i.e. people who are not computer savvy and whose extensive experience with computers is reading the news and that's it, we wouldn't suggest having an electronic meeting, because that would likely disenfranchise many of the owners who may be seniors or elderly or just not computer savvy. They wouldn't be able to, understand, or they wouldn't be comfortable to vote electronically. They wouldn't be comfortable to, quote unquote, attend electronically. And so what would happen is, you might not get quorum for your meeting. And if you did get quorum, there'd be a lot of people that would be unhappy, because many owners like to go to the AGMs. They like to hear what the auditor has to say. They want to have their questions answered. And of course, many things can be done electronically, but it makes it difficult if you're not computer savvy. So again, it depends on your community. I think the boards have a good feel, or should have a good feel, of the pulse of their community, and would be able to decide which course they want to take. Next question from LAA. I must know you, but you are definitely using your hidden name today. Hello, Brian. If AGM is held 3 months before a director's term expired, can election of a new director be still at AGM? So if the AGM is held 3 months before a director's term expired, you can at the AGM vote in a new director for the term. Ideally, you don't want to be in a situation where you have an appointment, and the appointment lasts 3 months, until you get to the AGM. But I would suggest that if the AGM is held 3 months before, if the AGM is held 3 months before the term expired, I'm going to suggest that the board member may wish to have his term ended by the AGM, so that everything is done in a clean manner. Iris Michi, the board of directors term expires at the date the AGM is being held. Yes, it usually does. It's the AGM that really is the determining factor on the terms. Jerry Gould, can we postpone an AGM for 2020 and cover 2 years in 2021? That's a fantastic question. And we've actually done that, where we have had condominium corporations that for whatever reason have not had their AGMs. And then we have had an AGM. We have put in the meeting package the financial statements for the year the AGM is for, as well as the years that the AGMs were missed, and we do the whole thing at one time. So the answer is, if you missed your AGM, for example, in your 2020, you move ahead in 2021. Your 2020 is done. You haven't had it, but in 2021. You will include the financial statements and the minutes from previous meetings and all the things that you would have done in the meeting that you missed, and you put it into your 2021 meeting. Now, this is an excellent question coming from Mel W. We are here now in May. So what does that mean for many condos? It means that the landscaping season and the construction season and the garage repair season and the balcony repair season is coming up. And, the truth of the matter is, people want to work and people want to move forward with their contracts because they have ordered supplies and material, they have labor and staff, and they want to get rolling with their business. So this is a good question. The window washers want to start cleaning windows after May the 4th. Are they correct? So let me say this. We have an issue in the condominium industry. And the issue is that only certain type of residential construction is deemed to be essential work. And if it's not essential work, then it is not something that is allowed to be done. It is properly closed off. So what we have is an order that says you can only do essential work. And there are many contractors that are trying to shoehorn themselves in as essential work, and they're not. And so what does that mean for a condo corporation? So it's important that everybody understands that the emergency order is a serious item. It's a serious item because the government passed an emergency order. And the government passed an emergency order because there's this vicious virus out there that is killing people and spreading more rapidly than your weeds. And you can tell the landscaper I said that. If you allow a contractor, whether it's windows, whether it's balcony repair, whether it's landscaping, and it's not essential because there's no urgency to the matter, there is no detrimental effect to the property. It's a non-essential contract. The condo corporation and the board members and the property manager and the condominium management provider, i.e. the company, can all be held liable. And I will tell you that if you contravene the emergency order and you are an individual, you can face a fine of up to $100,000 and a term of imprisonment for 1 year. If you are an individual who is a director, i.e. a board member, you could be liable to a fine of not more than $500,000 and a term of imprisonment for not more than a year. And if you're a corporation, whether it's a condo corporation or a management corporation, you can have a fine of not more than $10 million. Whoa, $10 million. So I'm not going to suggest, and I'm not going to suggest that if a contractor wants to come and do work, and I understand why, everybody needs to make a living. If the service is a non-essential service, you as a board member, you as a manager, you as a management corporation are looking for a potential big headache. And don't say, I didn't warn you. Next. Jerry DiDonato, can you suggest anything that a board can use to encourage owners to stand for election to the board? This is the million-dollar question, which I don't know. It's sort of like, how do you get the caramel in the Cadbury bar? It's really hard to encourage people to get on the board. People in condominiums bought into a lifestyle. They don't really, the majority of people don't really want to be involved in that. However, if you've been in the condo industry for many years, you would know that if the condominium is your major investment in your life, it's not a good idea to have no involvement in your condominium community. And you only need to look at some of the case law as to what can happen when board members who are not having the best interest of the condo corporation as their primary purpose for going on the board. A lot of bad things can happen. So I think you have to educate people. And in addition to educating the owners as to why it is a good thing to come on the board, I think that the community in general has to be respectful to the board members, because what they're showing, if they're not respectful to the board members, why would anybody want to go on the board, give up their free time, be volunteers, and then be abused for all of that? So for all the time you're spending and all the, the efforts you're putting in, the compensation you get is abuse. So nobody would want to be on such a board. So good idea to educate your community and try to encourage them to go on. Next. Adib Nasehi, thank you, Brian. If a resident makes a personal injury claim, example, elevator incident, which would be more preferable to go through, either the corporation's condo lawyer or with the insurance lawyer? So first of all, let me tell you this. There's a presumption, and it's a wrong presumption, that if any damage or any injury happens in a condo, the condo corporation is liable and needs to pay. So whether that is the garage door falling on someone's car, whether it is somebody slipping in the lobby, whether it's the elevator door closing on a person, the presumption that the condo corporation is liable and therefore must pay damages is 100% wrong. So what do all of these type of cases have in common? All of these cases deal with negligence. And in order to prove the condo corporation as liable, the unit owner has to show that there was negligence involved on behalf of the condo corporation, and that negligence directly related to or directly caused the damages. So it's the issue of negligence, it's the issue of occupier's liability, which makes the condo corporation liable for the common elements. So would you use a condo lawyer or would you use the insurance lawyer? My preference is always to use the condo lawyer, because the condo lawyer understands condominium law, which is different than other types of law. Having said that, most of the insurance companies have their own panel of lawyers that do work for them for all cases. What you need to do is you need to aggressively pursue your insurance company, your insurance adjuster, to try to ensure that they allow your condominium lawyer to do the work, and you will get a result which I feel is almost always better using your condo lawyer. Next question here. Mel W. Thank you, Brian. I believe they were basing it on Doug Ford's announcement on Monday afternoon. I will tell them no. Okay, so Doug Ford hasn't come out yet with any type of suspensions or amendments to the existing emergency order. So let's see what happens with his next press conference. Again, everything with COVID, with respect to the law, and we're talking about condominium law, is something that is ever moving. It's moving every day, all the time, every week. That's why we update our COVID-19 FAQ every single week. And sometimes before we send out our FAQ, we already have 3 or 4 amendments and amendments to our amendments, because everything keeps changing. But you can rest assured, Mondays, you get 100% the most updated information on COVID. Ron Britt. We engaged and gave a contract last fall to our landscaper to repair a trip hazard on our common interlock sidewalk, as well as a fence replacement. Okay, but there's no question there, Ron. So I'm going to tell you this. Trip hazard, yes, that's something that deals with safety and security, and you're fine to have somebody come on the property to fix that. Bruna has a question here. The landscaper says that apart from landscaping, they do property maintenance and cleaning, which they actually do. They're still coming on site and adhering to physical distancing guidelines. What do you think? Well, what I think, I guess, is what I said. For any type of contractors coming onto the property, it has to be an essential service. It has to be for maintenance and construction type of things. It has to be sanitation, safety, security, that type of thing. That's what it says in the order dealing with essential services. So, as I said before, if you breach the order, there's a liability. Does that mean that someone's going to come out to your condo tomorrow? Maybe yes, Bruna, since you put your condo corporation number here in the chat line. So maybe you have to rethink what you're doing there. Ron Britt, I provided a letter to them stating that this work was ordered last fall, but the weather changed to prevent it from starting. Are we okay under these conditions? Always, again, the issue is it essential? Is it safety and security, sanitation, etc.? If it falls within the guidelines, you'll be okay. So I just want to switch over here for a moment. We do get, from time to time, as I have said before, fan mail. And one of the things I want to do is read just 2 pieces of fan mail that came in, if I may. So the first one says the following. I am a property manager and I've been following up on your videos. Thank you so much for providing immense information to all property managers, especially during this pandemic situation. You are doing a great job. We all heartily appreciate your work. I believe you and your company issues updates or publishes frequently asked questions. If you don't mind, please send me a copy of the FAQ. It would be highly appreciated to send me the newest issue. So I want to thank you for sending that, and we are happy to send the FAQ to anybody who's not getting it directly. We'd ask that if you subscribe to this channel or just give us on the chat line here, say, please send it to us. Here's my email. We're happy to send it off to you. Now, I'm going to just read something else here, which I found a very troubling situation. Again, it came in from our fan mail. It's as follows. It's from a condo manager. And the condo manager read our FAQ, where it said that property managers really should be working not in the office, but from home, unless they have to do inspections or emergency work, because that's what the emergency order says. Property management services, only essential property management services for this type of emergency procedures. And we set that out in our FAQ. And the manager wrote us as follows. As per your FAQ, management asked the board to remotely manage the site and visit the site in case of emergency, but they rejected the idea and emailed us back that, quote unquote, we as a client requesting a property manager from 9 to 5. In this situation at this condo, there are 2 positive COVID-19 in the building, and the board does not allow the site property manager to call in professional sanitizing. The cleaners just clean the common area with sanitizing spray, and I, as a site manager, informed, had a bad flu, self-isolated for 2 weeks, returned now to the site. I am over 50 years old. I have a pre-existing health issue. I have problems with my kidneys. I have high blood pressure and other physical ailments. So this is a really distressing email, I must say. And it's a problem in the condominium industry where you have, unfortunately, board members who are intimating or threatening to either terminate a management contract or to terminate a manager or an administrator because the administrator or the manager just wants the condo corporation to follow the law and to allow the manager to work offsite unless there's an emergency. And why does the manager want to do this? For the simple reason, the manager would prefer not to die. Simple as can be. The manager would prefer not to get COVID-19. Is that an unreasonable question? I think boards who are, and especially this board, but boards who are insisting that managers work on site, don't understand what managers do, because a lot of what managers do is desk work and things that don't require them to go outside. A lot of things can be done on their computer, can be done in the safety of their residence. So to intimate that you would terminate a contract or a manager would be terminated for refusing to risk his or her health is really inappropriate. It says a lot of bad things about that condo and about our industry. So going back to the penalty phase, perhaps this condo corporation would be a prime candidate for a fine or a penalty, which is a provision for those people, those directors, and those and others who are not complying with the emergency orders. If you are a condo board member and you are insisting that your management team be on site at all times, you're in breach of the order. Don't say I didn't warn you. Next. What is the process of appointing or electing a new auditor? Thank you. The process of appointing or electing the new auditor. This is something that is a responsibility of the owners. The owners have the responsibility to appoint the auditor. It's normally done at the annual general meeting. If you do not reappoint the existing auditor, then the auditor continues on as the auditor for the corporation. So if you wanted to change auditors, you would properly secure quotes from different auditing firms. You would then bring these quotes to your AGM as a board, or you would include them in your meeting package, and then you would discuss them with the owners who would vote on the change. Of course, it's professional courtesy to advise the existing auditor that you are deciding to have an owner's vote on this matter, so that the auditor can make any representations before he leaves. And as chair of many meetings where this has happened, I would insist that after the auditor makes his representations, he leaves so that the owners can have a frank discussion and a vote as necessary for the appointment. Now, Jerry Mogiarati has another question here. A resident of our building wants to use the sauna for medical reasons once a day. Are we allowed to open the sauna to this person? Well, you have to accommodate people with a disability. You also have your COVID-19 issues dealing with the sauna. The issue about disabilities is that you have to accommodate, review what the medical issues are. I would seriously have a review of how the sauna is going to affect this person's condition. I might consider having my condominium lawyer review the material and then make a decision. Again, you have to accommodate up to the point of undue hardship. The question would be, does this person actually require sauna, or do they just like to have the sauna? And is it an undue hardship to the corporation? And it may be at this point to focus limited staff that are cleaning the entire building where there's a lot of surfaces that are being used, and take them off that job for the sauna. So that's the question there. Next question. OHSA, health and safety. The precedent is already in place. You cannot take action against someone who refuses to do unsafe work. A pandemic is a reasonable interpretation of unsafe work, full stop, says Murray Johnson. Murray Johnson, you are correct. There is a provision in the law that you cannot force somebody to do dangerous work, and you can't terminate somebody if they refuse to do dangerous work. Jerry Mogarati, what are the fines for doing non-essential work during the pandemic emergency? So as I had said before, if you are an individual, the fine is not more than $100,000 or a term of imprisonment for no more than a year. I don't think it's worth to wash the windows for that price. In the case of an individual who is a director of a corporation or an officer, a fine of not more than $500,000 and a term of imprisonment for not more than 1 year. I don't think that it's worth for the director to end up in prison unless he feels that that's a better place to live than his condo. In the case of a corporation, to a fine of not more than $10 million. So it doesn't seem to be worth breaching the law. Next question, Alexandra. We know that we cannot have our contractor start the irrigation system. However, if irrigation can be turned on by our supers, would that be fine? Well, again, the issue always comes down to safety and security. You have there the supers that are doing their job. I'm going to suggest that as part of the super's job, I mean, he's got to maintain the social distance, and it'd be acceptable for him, to turn on the system. But I wouldn't be having, other people coming onto the property. What is the process of replacing a property management company? Well, that certainly is an aggressive question. It's simple. You need to review your agreement. Everybody has a management agreement. In the management agreement, there is a termination provision. You would follow your termination provision. It's likely that the termination provision is 60 days or 90 days. You would, provide the written notice as it's set out in your management agreement, and you would ensure that there would be a proper turnover of books and records, as I'm sure there would be. That's an obligation under the Condominium Management Services Act of Ontario. and away you go, you're on to a new manager. Show that manager a thing or two so that he shows up during a pandemic. All right. LAA, back again. Is it possible that voting number of units can be increased by perhaps dividing some areas to smaller units? So you only have so many units in a building. Those units are set out in a schedule to your declaration. The residential units, let's talk about residential, it's 1 vote per unit. So I don't see how you're going to divide up the areas. You have 1 vote per unit, and that's 1 vote per unit. That's all you got. Olivia, how are you? As per the new order, restrictions on residential projects inside units or common elements should be postponed. Can you please give some examples of the residential project as non-essentials? You have to go to the definition of what makes a project essential, and you have to look at, safety, security, sanitation. These are the type of things that urgency that need to be looked at, and say to yourself, well, does this contract fall within what the emergency order says is essential or non-essential? That's really the determination. We have here Andy Tom. Would you be able to answer Eric Adams' question? If an owner is having work done inside his unit or home, does that mean that the Condo Corp should be held liable under the Emergency Act? I'm going to suggest that the way in which the emergency order is set out, the way in which the fines are set out, is a broad definition. It's every person who fails to comply with the order. And given that the condo corporation is the occupier of the common elements and it has the right to prohibit someone from entering the condominium corporation property, I think there would be a liability on behalf of the condo corporation in that regard. And so it's not a good idea at all to have these renovations going on inside the units. In fact, it's not allowed as of, I believe, April the 4th, unless the renovation was ongoing. I will also say that there are a number of other condo corporations that, whether the renovation was ongoing or not, have set a policy that there are to be no renovations during the COVID-19 period of time, and are looking forward to the Ontario government's loosening of their orders and when it would be appropriate to allow renovations to continue. Now, I just want to say a few more things here, if I can. So, again, if you are finding our live stream of value, I would ask that you press the subscribe button. I would also ask that if you kindly leave a review on Google, that will be helpful, especially to condominium lawyers who, when they send out compliance letters, receive reams and reams of hate mail. Even worse, people hate condo lawyers even more than they hate their managers. Think about that. Very good question just came in. If a condo corp posts a notice disallowing in-suite, non-essential work, does this pass liability to the owner and away from the corporation? It's an excellent question. I'm going to say that there may still be liability on the corporation and the manager because, again, the emergency order, the act is written very broadly. I would say that, the primary liability would be to the owner. But then again, there would, this is something under the Provincial Offences Act, and they would look at all of the various, the evidence surrounding that as to how the person was allowed to come on there, because again, management says who, and the board says who will be going into the service elevator or not, who will be coming through the building or not. So you can't have a blind eye and say, well, I had nothing to do with it. All right, so we have here one last thing. I see that our questions are coming to an end, and we've been on for quite some time. There is a real question here. When we go on watch, various television today, everybody is working from their home, and there's a lot of various ways that people are working, and people are doing things which are different and new. One of the most exciting things, I guess, in everybody's life today is going to the food store. That's not exciting at all. That's actually full of anxiety. But one of the most exciting things is going to the food store and seeing that there's still a bag of flour there, and grabbing that bag of flour for yourself and one for your kids, and then everybody's happy. And we see a lot of concerts and shows on, etc. So I want you all to know that people that have been watching our live stream say that every great show needs a band, and all of the talk shows at night, you see a band. And for many people know, but a lot of people don't know, is that I play a saxophone. And a lot of people are asking me to play my saxophone on this live stream, and I said no. But so far, the pressure is becoming almost insurmountable. So if you have any comments about that, please put it in the chat. And if people want us to do it, I will consider it. But I need you guys to set out what would be the most appropriate song. And I'm thinking We Are the Champions would be appropriate, because all of us in the condo business, we are champions. We're on the front line, and we're working really hard. So before we wrap up, there's a few last questions which we'll grab, and then we're going to sign off until next week. Mel says, a manager who must come into their office 2 to 3 days per week, as per their board, what can the manager or their head office do or say about it? Again, this is the unfortunate part of our industry, is that a management contract has a short lifespan. In other words, management contracts, for the most part, have termination clauses on, let's say, 60 days or 90 days notice. And, it seems that some of the boards are pressuring the managers to be in the office, which is not appropriate during this period of time. And it's further not appropriate for directors to say, but if you're not coming in and I don't see you here, I'm not paying you, or I'm going to pay you less, because there's a tremendous amount of time that managers spend at their computer and on their phone, all of which can be done from the safety of their home. So for those condo corporations that think that they can skirt the law by putting their managers at risk, they may be hearing from people, and they may not like what they're hearing from those people, especially if they're inspectors from the provincial offenses department. Murray Johnson, where is the sax? Oh my God. You see, the pressure is really starting to build here, I've got to say. How does one sign up for the Monday FAQ email? If you can just send in an email to me, to myself, B. Horlick, HORLICK, at HLD for David Lawyers, LAWYERS.com. I'll put you on the list. Happy to do so. Ron Britt, a bit off the topic. Why all of a sudden were board members of CAO asked to resign due to conflict of interest? Where do we stand going forward? Ron, you wanna make me cry. That's what you want to make me do. CAO, I don't know what happened there. There were allegations of conflict of interest by at least one of the members on the board. I don't know what the conflict of interest was, so I can't say, but the whole thing needs to get straightened out. The condo corporations are paying a fee to the Condominium Authority of Ontario. The Condominium Authority of Ontario has good legislation, is doing a good job for condos and for owners, trying to put the entire industry on a new level, on a proper level, and they need to clean up what's going on the board. I don't know what it is, but definitely it's disappointing, whatever it was. Next question. Oh my God, people are talking about me playing the sax. I should have never mentioned it. Oh my God. All right, so so ladies and gentlemen, I want to thank you all for tuning in. Again, the live stream will be next week at 12 noon. The FAQ comes out Mondays, and we're going to start doing the condo corner, a special little 2-minute short video on updated case law. That's Condo Corner. Again, if you could please press the subscribe button, that would be great. And again, if you enjoyed what we're doing, please leave a Google review. I thank you all so much for your time, and we'll see you next week. Bye-bye.